Hi guys, welcome back to Battle with Ola. This is Mujela Olu, and today is going to be a very interesting day because we're going to be talking about the fruit of a poisonous tree doctrine, improperly obtained evidence or illegally obtained evidence, and Musa Sadau and the state. You'll find out very soon how they all connect. But I want to make a shout out to Didelu Aladitola Adigun. She's my friend. She was the one that helped me register the case of Musa Sadau and the state. We're still in university, at the University of Ibadan. I think that day we were just discussing something on criminal law and we talked about improperly obtained evidence. Maybe we were doing revision for an exam. It was just a random discussion and she just mentioned Musa Sadau and the state as, you know, that case that you could use to back up the principle or the position of the court on improperly or illegally obtained evidence. Probably evidence law or criminal law. I think it must have been evidence law. And she just said it, you know. So since that day that case registered in my mind. So anytime I remember Musa Sadau and the state, I remember the day. So thank you so much. Shout out to you. So Musa Sadau and the state is like one of those cases that I easily remember, just like Garba University of Maiduguri. You'd remember when we talked about that case on the channel, I told you that was the first case I heard as a law student in 100 level. So I have not forgotten. So each time I remember Musa Sadau and the state too, I remember it easily for improperly obtained evidence. I always remember the day. So let's talk about it today. We'll start from the fruit of a poisonous tree doctrine. We'll take it one after the other. I will read some provisions of the Evidence Act to you and we'll take it from there. So if you haven't subscribed to the channel, please subscribe, like the video, and leave me comments in the comment section after you might have seen it. Bring your friends along to Battle with Ola. We're doing something important here and we want you to join in. Thank you so much to all those who have joined in. You know, thank you for the likes, the subscriptions, you know, the comments, the questions that you keep coming. Thank you to everyone that has streamed our last IG live where we brought a lawyer to talk to us and to demonstrate adumbration on the request of some viewers of the channel. We are bringing one more lawyer because when I made the call on my social media page, I asked for 2 litigators to please come and talk to us about adumbration. So one more person has shown interest. So when we finalize our discussion, they are going to come on the channel and adumbrate for us again. And I'm glad with the feedback that I've got so far from people who have streamed the videos. And I know it will be particularly useful for law students and those who are involved in Mutamok. So thank you everyone. Let's dive into today's affair. The fruit of a poisonous tree doctrine is just a rule that says that, you know, evidence obtained improperly or illegally is not admissible. It's a general rule and it's upheld in a few countries, such as the United States, for instance. If you watch the police drama crime series Rookie, if you watch it in one episode, I think season 5 or season 6, either season 5 episode 6 or season 6 episode 5. No, season 5 now. It's season 5. I remember that. Episode 6. You know, Nolan was now also a trainer and then he had a new boot. And the new boot was someone that was a bit eccentric and she would say that she was feeling auras, you know. She was feeling vibes, you know. And then they had stopped a woman and she had conducted a search on the woman's vehicle without probable cause. So you need probable cause to conduct a search on someone's vehicle during a stop and search. Else, any evidence you retrieve in that process will be inadmissible in a United States court. So they have that rule. There are a few exceptions to the rule, but generally the rule is that if there's no probable cause and you just stop someone on a whim, search their car, retrieve evidence, you cannot tender it in evidence because it will be inadmissible even if you do. So that's the rule, and that's the easiest explanation, I believe, for the fruit of a poisonous tree principle. So essentially, it's saying that, you know, when a tree is poisonous, the fruits from that tree will certainly be poisonous. So that's the application of the rule. And that's to say that you must follow due process even in obtaining evidence. You cannot say that, oh, because you have a zeal for catching criminals, then you trample on their human rights and then you just muddle things up. You disregard laid down principles and rules of obtaining evidence just because you want to get evidence and you want to tie someone to the commission of a crime. In Nigeria, that's not the case. The fruit of a poisonous tree may be deemed not poisonous That is to say that in Nigeria, evidence obtained improperly or illegally is still admissible in court, largely. Now, I believe the court looks at everything on a case-by-case basis, but generally, the rule of the principle of the practice is to admit evidence so long as it ties to the case. I don't know if we've done relevance and admissibility on the channel. I'll look through. If you haven't done it, I'll do a video on that, and I know that it will be splendid and it will be very helpful. In Nigeria, relevance governs admissibility. That's a key principle of evidence, so that you should know, especially if you're a law student. Just register it and you're home and dry, because you will use it throughout your law career. In Nigeria, relevance governs admissibility. That means that if a piece of evidence is relevant to the case and we help the court, arrive at a fair determination of the matter, the court will admit it, regardless of how that evidence was sourced. So that's why I say that the principle is not admissible. Musa Sadau and the case that we're going to discuss is a 1968 case. That means that it came before the 2011 Evidence Act, but the position has not really changed, and we're going to get into it one after the other. Now let's read the provisions of section 14 and 15 of the Evidence Act. That a portion of the Evidence Act is titled Improperly Obtained Evidence. Let me read it out to you. Improperly obtained evidence. Here's what it says. I'm coming. A minute. Here's what it says. Evidence obtained, that's section 14. Evidence obtained improperly or in contravention of a law or in consequence of an impropriety or of a contravention of a law shall be admissible unless the court is of the opinion that the desirability of admitting the evidence is outweighed by the undesirability of admitting evidence that has been obtained in the manner in which the evidence was obtained. And then 15 says, for the purposes of section 14, the matters that the court shall take into account include the probative value of the evidence, the importance of the evidence in the proceeding, the nature of the relevant offense, cause of action, the nature of the relevant offense, cause of action or defense, and the nature of the subject matter of the proceeding, the gravity of the impropriety or contravention, whether the impropriety or contravention was deliberate or reckless, whether any other proceeding, whether or not in a court, has been or is likely to be taken in relation to the impropriety or contravention, and the difficulty, if any, of obtaining the evidence without impropriety or contravention of law. So that's what the law says about evidence obtained illegally or improperly. But largely, you would see that what the court is saying without saying much is that we will admit all forms or all types or all kinds of evidence that is furnished to the court, in a matter, so long as you can tie it sufficiently to the case and the delivery of justice in that particular case. So that's the rule in Nigeria. That's the general rule. In Musa Sadau and the state, Musa Sadau and some others had been accused of forgery, of printing fake vehicle licenses generally, and selling it to motorists in Kaduna. And they had been accused, arraigned, and convicted by High Court sitting in Kaduna, and then he appealed. So he had appealed and said that the evidence they tendered was improperly obtained, and that they had not complied with the provision of law, regarding execution of search warrants, and that his sentence was excessive, So what he had contended during trial, which the court did not believe and did not hold for him, was that he was actually a bicycle repairer. He did not have any business with printing vehicle licenses, that the policemen that came to search his house had brought a bag full of fake licenses rather. I keep saying receipts for a reason. I'll let you know why later. Fake licenses, and they had planted that evidence in his house. That they brought the evidence and planted it, not that they found it in his house. And so he was denying that he committed the offense, or that that evidence was found on him. And so he appealed. So we're going to discuss the appeal. I keep saying receipts instead of licenses because, I was also in a forgery matter a few years ago, and I think I've sufficiently discussed that matter on this channel. In that case, we had prosecuted some road transport union workers. The DSS had arrested them after surveillance and all of that, and they were prosecuted them for forgery. They were basically producing fake receipts, fake government receipts. So they had a quota of government receipts to sell to motorists per day. So they would take it from their chairman or their coordinator at the park level, and then they would take their own fake receipts. So they were selling both interchangeably. So they were making money. So we put them in the dock and then we tried them for forgery. Forgery is a very important or serious offense. It's not serious on the books, really. I think it's 14 years thereabouts, if memory serves me right. But it's a serious offense to me because it tampers with the economy of the state in this type of cases. Because essentially, if you're supposed to sell 100 tickets and then you decide to sell 50 of yours and 50 of government tickets, that 50 will go to your pocket, the proceeds. So government is losing for 50 tickets per day because of your acts of forgery. So that's why I consider it very serious. And the court held so in Musa Sadau's case too, that in fact at the appeal level, the appeal court justices had said that they find the sentence meted out by the lower court to be mild because that was an offense that tampered with the economy of the state of Kaduna. So on appeal, he said the sentence was excessive and that the law had not been complied with. According to section 78(1) of the Criminal Procedure Code, which is what applies to the northern states, according to that section of law, it says that when such a search warrant is being executed, 2 neighbors should be invited to be present. So Musa Sadau was contending that his neighbors were not invited during the search warrant, and so the police had brought their own evidence and planted it on him that if his neighbors, it was essentially saying, if they were around, they would have testified to the fact that this thing was not found in my house, blah blah blah. So I'm a bicycle repairer, I don't make fake licenses and all of that. But the court did not believe his story. The court believed the prosecution, held for the prosecution and sentenced him. Now on appeal, the court looked at his grounds and said that first and third grounds would fail, and that the second ground, which was the non-compliance ground, would also fail. And the court held that the provision for the police or the prosecution to have 2 neighbors present during a search warrant was not mandatory, so it did not affect the procurement of the evidence that was gotten or obtained from his house. Let me read the provision of section 78 to you. Section 78(1) of Criminal Procedure Code. Searches under part B of this chapter shall, unless the court or justice of the peace owing to the nature of the case otherwise directs, be made whenever possible in the presence of 2 respectable inhabitants of the neighborhood to be summoned by the person to whom the search warrant is addressed. So that's the provision of law. So Musa was saying that his neighbors were not invited during the search warrant, but the court said that that does not affect anything. They do not have to be there, and so the court admitted the evidence. So essentially, Nigerian courts availed that improperly or illegally obtained evidence is admissible if relevant. Now, the fact of how the evidence was obtained improperly or illegally will or may only affect the weight at the court will attach to the evidence, but it does not generally affect the admissibility. In Igbinovia and the state, that's another old case before the Evidence Act of 2011. In that case too, a police officer had been planted in the cell of the accused person when he confessed to the crime. So, it was like entrapment basically. But the court had held that entrapment is not a defense in Nigerian law. And so the confession was admissible, even though it was an oral confession. And even though he had done it thinking probably he was talking to a co-criminal, the court held that it was admissible. So that's the rule generally in Nigeria. In Nigeria, in the US, and in some other countries, the fruit of a poisonous tree is poisonous and not to be eaten. But in Nigeria, the fruit of a poisonous tree is not always poisonous. For instance, in Igbinovia and the state, the court had held that, Section 15, the decision of the court was in line with the current Section 15 of the 15F of the Evidence Act 2011, which I read to you earlier, which says that the court would also consider how difficult it is to have otherwise legally or properly obtained the evidence. So if he had been talking to a police officer and they were trying to extract a confession from him, he would not have confessed to the crime. There was no other proper legal way they could have got him to do it. So the court held that that was okay. So the court will consider all those things that we read in section 14 and 15 of the Evidence Act. Please read it for better understanding, and let's continue the conversation in the comment section. But generally, that's the principle. So the appeal did not succeed in Musa Sadau and the state, and so it's a case that you can still cite to say that evidence improperly or unlawfully obtained is admissible. Of course, in modern day litigation, there's no watertight application. Things are considered on a case-by-case basis, because in Musa Sadau and the state, some of the things that also affected this case was that the court also noted that there was no authority, judicial authority, provided or cited by his lawyers to say that the court had decided otherwise in times past, to serve as a binding precedent that if evidence is obtained this way, it should not be admissible, and that the appellant had not called upon the court to make a rule regarding that. So they were notified at Christmas. Essentially, that's what they're saying, that we're not here to decide what you have not asked us to decide, so we're not going to meddle, and you have not provided any binding precedents to say that this is how it was decided, this is how you should decide. Also, the court said that it was hinging its objection as well to the admissibility of the evidence on the fact that witnesses were not called by the prosecution, witnesses that were not invited during the search warrant to testify to the veracity or the reliability of the evidence obtained. So the court said that he relied on another section of the law. So essentially, prosecution had furnished sufficient evidence, and so the court upheld the decision of the trial court. So that's what happened in Musa Sadau and the state, and essentially that's the position of law in Nigeria. But since cases are tried on a case-by-case basis, I believe that if someone or a party is able to prove to the court that the obtaining or furnishing of such evidence before the court is not just merely should not merely be inadmissible because it was obtained improperly, but because it contravenes another law or contravenes a fundamental human right, or will go against the grain of justice in that particular party's case, I believe the courts may hold in their favor. So it's not a watertight principle, but it's a general principle, and that's how the courts have decided over time, before and even after the Evidence Act 2011. Leave me comments in the comment section. Don't forget to like the video. I'll see you in my very next video. Toodles.